Hello, it is now 2 p.m. Eastern Time. You have joined the 2022 Fieldwide Webinar, Prosecutorial Diversion Programming Collaboration, Early Intervention through Reentry. To allow for additional signees past the hour, we will start the webinar in a few minutes. Good afternoon. Thank you for joining today's Fieldwide Webinar, Prosecutorial Diversion Programming Collaboration, Early Intervention through Reentry. I am Demetrius Thomas, Deputy Program Director at the Council of State Government's Justice Center. I will be moderating today's webinar, which is funded by the U.S. Department of Justice, Bureau of Justice Assistance, commonly referred to as BJA. To give you an overview of today's webinar, first I will introduce the presenters. Then I would do a brief overview of the Bureau of Justice Assistance, BJA, the Council of State Governments, CSG Justice Center, and the Justice and Mental Health Collaboration Program, commonly referred to as JMHCP, TTA, and the Association of Prosecuting Attorneys, APA. After that, presenters will lead us to a presentation. After the presentation, there will be a question and answer portion, followed by a quick wrap up. Anytime during the webinar, you can ask a question by dropping your question into the chat box at the bottom of your screen and entering your question. This includes both technical and content related questions. We will try to reply to technical questions in the chat window as we go. For those content related questions, we will keep a running list and address them at the end of the webinar. We will do our best to get through as many questions as possible. If you encounter technical or audio problems during this webinar, please click on the links dropped in the chat box. Please understand that there are some technical issues that we may not be able to resolve. However, the webinar is being recorded and we will post it on our website as soon as possible. Next slide, please. Oh, you're already on it. Introducing you to our speakers, we have David LeBlanc, who is the staff attorney for the Association of Prosecuting Attorneys. David joined the APA just recently in September of 2022 after 3.5 years as an assistant district attorney with the Orleans Parish District Attorney's Office. David served New Orleanians in many roles. He was a trial attorney in the juvenile and felony divisions before spending the past 2 years in the appeals division litigating direct appeals, state post-conviction relief, and federal habeas corpus applications. David graduated cum laude from Southern University Law Center in May of 2018. During law school, David clerked in the Louisiana Attorney General's Office Criminal Appeals Division for 2 years. David received his bachelor's in science and health and human performance from McNeese State University. Also joining us as a presenter is Todd Williams, who is the district attorney at Buncombe County, North Carolina. Todd attended the UNC Chapel Hill, graduating in 1992 with a BA in English. While attending Northeastern University Law School, an internship in the law firm of a renowned civil rights attorney turned Todd toward criminal justice law. Todd worked for nearly 15 years as a public defender and as a capital defender. By 2014, the integrity of the Buncombe County justice system was at an ebb, and Todd ran as a candidate for DA to restore it. Todd defeated a 24-year incumbent, and took office as Buncombe County DA on January 1st, 2015. Todd was reelected in 2018 and then again in 2022. As a DA, Todd and the office he leads have resolved heinous crimes while concurrently working to reverse questionable past convictions and expand access to justice across the community. Also joining us today is Shauna O'Lee. Shauna O'Lee is the jail diversion case manager for Buncombe County, North Carolina, and works with individuals who are incarcerated to assess their needs and link them with supports in the community. She is a licensed clinical health counselor associate and a licensed clinical addiction specialist associate. Prior to beginning her work with RHA Jail Diversion, Shauna worked in various roles in the community, supporting individuals with needs related to substance use, mental health, and trauma. Shauna spent several years working with people experiencing intimate partner violence, providing crisis counseling and safety planning. Additionally, she spent years working at the Justice Resource Center, where she implemented programming to support individuals with complex needs who were involved in the legal system. She graduated from the University of North Carolina in Asheville in December of 2012 with a bachelor's in psychology. She graduated from Western Carolina University with a master's in clinical mental health counseling in 2021. Rounding out the presenters is Evan Nabcom, who is the Intensive Forensic Service Supervisor at the Deschutes County Behavioral Health. Evan is a licensed clinical social worker with 15 years of experience in the field of forensic mental health. His current role manages a team that is responsible for providing treatment and support to individuals with severe persistent mental illness who are involved in the criminal justice system at a number of contact points, both pre and post sentencing. Thank you all to the presenters for being part of this presentation. Next slide. Next, I'll provide overviews on the mission of the BJA, CSG Justice Center, JMHCP, and APA. Next slide. BJA's mission is to provide leadership and services in grant administration and criminal justice policy development to support local, state, and tribal justice strategies to achieve safer communities. Specifically, BJA provides funding to support law enforcement, combat violence and drug-related crime, and to combat victimization. Through the development and implementation of policy, services, and sound grants management, BJA strengthens the nation's criminal justice system and restores security in communities. Next slide, please. Now I'm going to tell you a little bit about the background of the Council of State Governments Justice Center. The Justice Center is a national, nonprofit, nonpartisan organization that combines the power of a membership association representing state officials in all three branches of government, with the expertise of a policy and research team focused on assisting others to attain measurable results. Our staff develops research-driven strategies to increase public safety and strengthen communities. Next slide, please. Oh, this is great. No, go back, you were right. This slide describes a bit more about our work style and how we strive to reflect Justice Center core values, which include a commitment to being independent and nonpartisan in every aspect of our work, providing vigorous, trusted, high-quality analysis, developing practical and innovative solutions informed by data and research, promoting collaboration and building consensus, and being inclusive and respectful of diverse views and experiences. Next slide, please. Today's webinar is part of the Justice and Mental Health Collaboration Program, commonly referred to as JMHCP, Training and Technical Assistance, TTA, which many of you may already be familiar with if you currently have or have had a JMHCP TTA grant. The JMHCP TTA promotes innovative cross-system collaboration and provides grants directly to states, local government, and federally recognized indigenous nations to improve responses for people with mental illness and substance use disorders who are involved in the criminal justice system. Next slide, please. Next slide. I just did. Oh, okay. The Association of Prosecuting Attorneys is a national nonprofit whose mission is to support prosecutors in their efforts to create safer communities through a more just and equitable legal system. Through publications, training, and technical assistance, and legislative analysis, APA serves as a forum for collaborating with criminal justice partners across the globe, and an advocate on behalf of prosecutors on emerging issues related to administrative justice. Next slide. Thanks everyone for joining the webinar. Now I'm going to turn it over to David, who will provide some context on prosecutorial diversion. David? David, you're on mute. It's not a webinar unless someone is on mute.
Embarrassing. So first of all, thank y'all for coming. I appreciate it. Thank you, Demetrius, for having me. So I just want to briefly talk about what prosecutorial diversion is. So generally, criminal cases are resolved in one of three ways: either through a guilty plea, a trial where someone is either found guilty or not guilty, or by dismissal. So what diversion is it's an alternative to that traditional prosecution of criminal cases, where instead of going to court and resolving your case that way, there's a program through the district attorney's office or the prosecuting attorney's office in that jurisdiction that gives people an option that will result in a dismissal rather than a conviction if they successfully complete the program. So in a prosecution-led diversion program, the DA's office or the prosecutor's office sets all the parameters for the program in terms of which defendants are eligible based upon various criteria such as criminal history, age, whether they have other cases open, mental illness, or whether they're a veteran, those sorts of things. They also determine what type of cases are eligible, whether it be only drug cases or only misdemeanors or certain felonies. And then the last thing they determine is what is the criteria for successful completion and how you evaluate whether or not someone has completed the program successfully. Next slide. So prosecution-led diversion has been around for, since the 40s, and really it has become more mainstream in the past 15 to 20 years because research has shown that the telephone crime policies of the 70s, 80s, and 90s have not been effective in enhancing public safety or in reducing recidivism or reoffending. So prosecutors nationwide have made it their prerogative to engage with local communities and with social services and meet people where they are on criminal justice issues and reform. Next slide. And so while prosecutors' offices may lead the diversion program, what a prosecution-led diversion program really is a collaboration between all these groups of people, the public, the defense bar, the bench, and law enforcement, social services, and probation and parole services. And next slide. And so all of those groups sort of fit into one of these three areas. So, and Todd is going to talk about this, I think, later, but if you're in a case like, if you're in a state like Louisiana where you're a prosecution charging state, well, then there's an opportunity for law enforcement to be involved even at the pre-booking stage. So in the city of San Diego, for example, they have a pre-booking diversion where if someone is arrested and they believe that person to be suffering from substance abuse, that person can, instead of being booked into a jail, the county jail, they can be checked into a treatment center and avoid the criminal justice system altogether. And, so all these interactions with a diversion program are going to start with the public, whether that's someone coming into contact with law enforcement or somebody, a family member or another member of the public calling 911 and law enforcement is involved. And then, of course, in all three of these different sections, whether it's a pre-booking diversion, a pre-filing or pre-trial diversion, or a post plea or admission diversion, social services and members of the public are going to be involved in this. And when we say members of the public, what we're really talking about are the defendants or the person who's involved in the criminal justice system, their support system, their family members, and the people that are going to help them to make it through these programs. And so at each level or in each version of a diversion program, and the district attorney's office or the prosecuting attorney will set parameters on which kind of cases are going to fall into each one of these three categories based upon their severity or the circumstances of the defendant. Okay, next slide. And then, of course, there are a myriad of benefits for a prosecution-led diversion program, but in my view, the biggest benefit of a diversion program is giving people a chance, giving them a chance to get the mental health or substance abuse treatment that they need, give them a chance to not bear the burden of a criminal conviction, but still be held accountable for their actions, and also to give them a chance to avoid the trauma of having to go to jail or prison. And with that, Demetrius, I'll kick it to you to talk about sustainability.
Thanks, David.
And the collaborations, yeah.
Thank you. Before we went into the presentation, we just wanted to highlight some best practices and key considerations when working with prosecutors and other collaborative partners in diversion programs. The first, we wanted to focus on building successful collaborations. The first idea is to identify and to begin working with cross-system partners immediately. To build your cross-systems partnership collaboration, it's important to take advantage of already established councils and task forces to find partners, supporters, and or other champions of your work. Develop a collaboration team that is racially and ethnically diverse and includes those with lived experience. Also, it's important to develop a shared mission and goals. Come to the table with reasonable goals and points of agreement. Be intentional about building positive relationships and avoid blame. Also, it's important to assign clear roles and responsibility. This may mean developing focused subcommittees that can enhance your program, such as marketing, community outreach, data and evaluation, finance, and other sustainability committees. Also, it is important to create clear policies and practices that details the committee, not only details the committee structures and functions, but as well as detailing the programmatic information of your program. It's important to meet often, and also it's important to be willing to adapt and readjust, particularly relying on the needs of your clients and program data evaluation, which we'll talk about a little later. Next slide, please. When thinking about collecting data, it is important to think about these questions. Who are your clients? What are the data points that address the mission and goals to support your clients? That includes baseline data, outcome measure data, as well as input and output data. Who has the authority over these data points? Is it a private entity? Is it a government entity? Is it a not-for-profit? And more importantly, are these partners a part of your collaborative team? These questions are important as they will determine how is the data accessible and how long would it take to receive it? Will you need to go through a formal request such as a FOIA or a FOIL, or is it a public record? Is it accessible through internet? It is also important to ask yourself, how is the data collected and where will it be stored? Is it collected by a staff person or the individual client, or both? Is it directly entered into a system, or is it entered at some later point? Is it stored in a central database or among several documents, such as an Excel spreadsheet or any other document? Also consider, how often are you evaluating your data? Data evaluation should be done regularly and used to define and redefine your program. It's also important to ask yourself, what information story will your data need to tell to champion the work? This is essential to program sustainability, which I will be addressing shortly. Next slide, please. Here are some important questions that you should be asking yourself when you're thinking about sharing your data. Is the information shareable? Does sharing it violate any privacy, confidentiality, and/or civil rights laws? What policies and procedures are in place to obtain clients' information? For example, are you using informed consent forms? What policies and practice are in place to share information amongst partners? Are you using MOUs, MOAs, or business agreements, or a mixture of all three? It is also important to ask yourself, what security measures are in place? Is the data stored in a secure location? Is there limited, restricted access to the data? And how long will the data be stored? Another question to consider is, how and how often will the data be shared amongst the partners? Data should be shared and jointly evaluated often and through a secure means. There should be policies and procedures in place around data sharing. Another question to consider is, are there policies and procedures around publicly sharing the data amongst the varying partners? Next slide, please. Here are some key considerations for financial sustainability. Financial sustainability should be considered at the start of and throughout your program. Far too many collaborations make the error of considering sustainability at the end of the program. Here are some tips when thinking about financial sustainability. Design a sustainable initiative. Clarifying what your jurisdiction seeks to achieve through your initiative will help you identify relevant funding, develop the appropriate sustainability committee, and bring funding to scale and to sustain it over time. It's important to develop a sustainability committee. A sustainability committee is a group of people representing various perspectives who are invested in the long-term financial health of the initiative. It is critical for community to include impacted populations and diverse voices. Absent their involvement, initiatives and their related budgets are in danger of reflecting the priorities of government agencies rather than the actual needs of the populations they are meant to serve. A sustainability committee also provides strategic oversight of the initiative's budget and drives efforts to secure future funding. Consider the various roles the committee needs to be successful when you help to staff the committee in a meaningful way. The Sustainability Committee could source roles and stakeholders from existing initiative planning and implementation committees, as these members might be strongly positioned to create sustainability plans as a result of their involvement in operating the initiative as a whole. It is also important to prioritize strategies to demonstrate impact. To obtain additional grant funding and advocate for the use of tax dollars, you need to be able to demonstrate the initiative's impact in a meaningful way and show that it is making a difference. To do this, it is imperative to identify strategies that demonstrate impact. For example, discrete efforts that show the initiative's effectiveness either through quantitative or qualitative data, or both. These strategies should be in service of the goals and program and policy components you listed under the initiatives designed. It is also important to determine the budget needs. Think through each key cost over time before you begin calculations to develop a funding plan. Consider how much of your budget is invested in communities that are disproportionately impacted by the criminal justice system as well as the behavioral health system. Identify existing funding, and it's also important to maximize your current funding resources. Your initiative should make each dollar go as far as possible toward achieving measurable impact. Emphasis on measurable. If through data and data evaluation, you realize something isn't working, it is important to retool it and redirect funding. Try to prioritize funding dollars, using funding with very limited discretion toward priorities where there are limited or no funding sources. Next slide. I'm now going to turn it over to the Buncombe team, who's going to walk us through presentations on their program. Todd, Shauna.
I can get us started here. Next slide, please. So again, my name is Shauna. I am in Buncombe County. I'm going to speak to you about some of the jail diversion that we have happening in Buncombe County. I'm part of a program that provides case management, treatment planning, and evidence-based group programming within the detention facility. We have 3 case managers that are embedded in the detention facility here. And we're in a unique position because we're in here, so we can provide information in the form of a recommendation to the court system, what this person might need, what plan this person might follow. And we can also serve as a resource to law enforcement. So this includes instances where someone comes in and they might be exhibiting some mental health features or some signs of substance use, or someone who's come into the facility multiple times over the course of the past month. What we're really trying to do is increase engagement for individuals with community-based services. And by doing so, we want to reduce the likelihood that individuals will be rearrested and enter back into the jail. Next slide, please. So again, our main goal is we want to prevent unnecessary incarceration. And this is especially true among individuals who are dealing with a mental health diagnosis or issues with substance use. The primary goal is to reduce jail time. We don't want people staying in custody for longer than they need to be, especially if they're going to be better served in the community, either re-engaging with services or resuming services that they have already been using. We also want to understand that while jail is not an ideal environment for people, it can sometimes be a critical intervention in which people are open to treatment or stabilization simply by the fact that they came into custody and that option is being offered to them. Next slide, please. So anyone that comes into the facility is eligible for our programming. Certainly their legal situation stipulates what we're able to do. We're not able to create a reentry plan and recommendations for everyone, but we're going to engage them in any way we can. And oftentimes that includes engaging them in evidence-based programming, engaging them in motivational interviewing, and getting individuals to start thinking about what supports they're going to want in place whenever they do leave, because everyone will leave. And of course, we have what I'll talk about later is special tracks for people who endorse substance use as their primary challenge, or who have a documented severe and persistent mental illness as their primary challenge. Next slide, please. We get referrals. This is the collaboration piece for us. We get referrals from everyone. We get bench referrals. So if a judge sees someone for a first appearance and thinks that they would benefit from speaking to us, we can get referrals from the bench. We can get referrals from public defenders. We can get referrals from family members. Oftentimes we collaborate with other agencies in the community, whether that's open access mental health agencies, domestic violence agencies, homeless agencies that say, hey, a client of ours is in custody, here are the supports they have in the community, and then we can meet with that individual and with their consent, make the recommendation that they continue utilizing those supports in the community to ensure that they don't come back into custody. Next slide, please. So the programs that I'm just going to briefly touch on today that fall under our umbrella are the substance use diversion, JEST, which is specifically for folks with documented severe and persistent mental illness, reentry, and then we also have a catch-all, which we'll talk about, which is named the Familiar Faces Task Force. Next slide, please. So substance use diversion, exactly what it sounds like. We have a unique opportunity here to ask for attorneys to go in front of the judge and ask for an individual's bond to be unsecured in order for them to attend residential treatment instead of being in custody. Right now, we have 2 treatment facilities that we work with and refer clients to directly from the detention facility. One of them is a 2-week program. The other one is a 30-day program. What these individuals also have the opportunity to do when they're in treatment is collaborate with their counselor and case manager while they're there to come up with an appropriate step-down program. And then what folks have the option to do is their attorney can continue to get their bond in front of the judge again to see if it can be modified for that person to continue whatever that step-down recommendation is. And these individuals are often monitored by pretrial during that process. Some special considerations here. Unfortunately, these treatment facilities that graciously accept folks from custody will not accept folks with violent charges or assaultive charges. Another special consideration is lots of times folks come into custody and they have out-of-county holds, meaning they have pending issues in other counties, whether that's a failure to appear or they have to have a first appearance. In those cases, we're not able to make these types of plans for individuals because as soon as their bond was unsecured, instead of going into a bed in treatment, they would have to go to another county to resolve those legal matters, and the plan would then kind of fall apart. So those are things that we have to think about when making this type of diversion for folks. Next slide, please. JUST is specifically for folks in the community that have a diagnosis in the state of a severe and persistent mental illness. Usually these folks are already engaged with enhanced services, which means they may have an assertive community treatment team or a community support team or some other type of wraparound service. And JUST is essentially trying to make the case to the court that this is an individual that is benefiting from these supportive services. There's a high likelihood that this individual's mental health factored in to whatever alleged crime they committed. And could we please make the case for this individual to resume these wraparound services in the community so that they can have continued access to social supports and the medication that we know is beneficial to them. Next slide, please. And then we have reentry services, which is essentially everyone, because everyone that comes to jail is leaving, whether they're leaving directly from the jail back into the community or whether they're going to get sentenced to DOC and then come back into the community. So reentry is offered to everyone, including those individuals that don't meet the legal or clinical criteria to get into treatment or don't have that diagnosis. So we meet with everyone and really start talking with them about what supports they're going to need in place, what have been the previous challenges, and start having conversations and giving them information about how they can connect with community resources when they are released from custody if we're not able to make a recommendation that their bond be unsecured for them to engage. Next slide, please. And then Familiar Faces Task Force is kind of a catch-all. Familiar Faces Task Force is for that percentage of individuals that can be very difficult to engage and that tends to utilize the jail as a means of crisis stabilization, right? They're coming into custody frequently, whether it's into the jail or into the hospital. And for whatever reason, they're never following up with whatever step-down plan is made, whatever crisis plan is made, whatever continuing care plan is made. So Familiar Faces is a collaboration in which providers that work in all different parts of the community come together and staff individuals so that if this individual is seen at the local homeless shelter, people will know who this individual is working with, when their next court dates are, what providers they have, what needs they have, so that we can work together as a community to offer support to individuals that aren't going to necessarily follow a written plan, but who would benefit and are receptive to some type of support. Next slide, please. So again, with familiar faces, what we really want to do is we want to meet individuals where they're at. We're hoping that this helps improve their health. We're hoping that we can help get them housed. Of course, we don't want to see these individuals consistently using the jail for crisis stabilization. And we also want to hopefully prevent these individuals from using the hospital or the emergency department for crisis stabilization, because we want them to have access to caring individuals throughout the community that can intervene before it gets to the point where they're having to come into custody or utilize the hospital for stabilization. And then I think this is where you can chime in, Todd.
Thank you, Shauna. That was excellent. Thank you, Demetrius, for the introduction, and David for the setup. My name is Todd Williams. I'm the district attorney here in Buncombe County, North Carolina. I was elected, as you heard, in 2014, took office in 2015. I ran under a banner of fairness, integrity, and justice. And there were a lot of issues here in Buncombe County. My predecessor was here for 24 years, and things needed an update. I came from a background of public defense. I was a capital defender at the time that I ran for this office. That being said, there were very few opportunities in the court system outside of prison, probation. North Carolina legislature did provide for a statutory deferred prosecution, which would be judicially supervised. There was drug treatment court, which generally, obligated the offender to plead guilty and be placed on probation. But there was no prosecutor-led diversion program here in Buncombe County. When I came in 2015, we did a systems analysis of what we had here in Buncombe County to achieve the aims of justice here, as a DA is obligated to do. And there was a program, or there was a court that was utilized here that for first offenders charged with misdemeanor crimes, they would be referred to a court where they would be oxymoronically told, the way to get your charge dismissed is to plead guilty. And it was sort of modeled on the drug treatment court protocol. So folks who are charged with nuisance crimes, petty theft, those kinds of things, first offenders, would be referred to this court. They would plead guilty, maybe do 10, 15 hours of community service, come back 6 months later, and if they didn't have new charges, a motion would be filed to strike their plea, and then if granted by the court, then the state would take a dismissal. And the folks that were in this court heard my charge was dismissed, which was true. However, we had multiple problems in that we were constantly receiving calls from chiefly military recruiters who were asking, was there a sentence imposed in the case? And there were sentenced to, the folks that were in that court were sentenced to unsupervised probation and were told to do community service. They also had to pay costs of court in that program. And there was also a post-conviction motion that was granted, and then a dismissal post the grant of that motion. We had an individual who had a professional license who went to renew their license and was told by the licensing board that they lied on their application to renew their license because they checked that they had never been convicted of a crime. Well, they heard that their charge was dismissed, but it was dismissed after a post-conviction motion was granted. So, after being elected, I felt like the path to do justice here in Buncombe County and in North Carolina was to utilize a prosecutor-led diversion program. And what you need to understand here in Buncombe County about criminal procedure here in North Carolina is that we are a police charge state, meaning police make an arrest, they go to the magistrate then issues a warrant and sets a court date, sets a bond, if that's appropriate. and the individual might receive services through the jail diversion program just described by Shauna. And that program was implemented probably 10 to 15 years ago as a joint project between Buncombe County government, the sheriff's office, and court officials, perhaps including the DA, but I think largely driven by judges. What I wanted to do was different. I wanted a prosecutor-led diversion program so that while we don't have discretion in once a matter is charged by law enforcement and the matter is initiated, we do have discretion about charges in terms of, reviewing for appropriate charges and that kind of thing. But while many of you may think that that's bizarre, that the prosecutor doesn't really initiate the case here in Buncombe County, and I've heard that as I've gone around and talked to my colleagues nationwide. What we do have here in North Carolina is we can dismiss a case as prosecutors for any reason or no reason, and that's pretty much unchecked by the system outside of the voter. And I just reelected yesterday. So the voters of Buncombe County have tacitly placed their imprimatur, thank you for the congratulations, on this program that I'm about to describe. We created for first offenders the adult misdemeanor diversion program as indicated on the slide. And that includes a track for the unhoused population here in Buncombe County because their needs are, some of those charges include sleeping in a park or public urination or those kinds of nuisance crimes, which, if an individual is living in a McMansion or what have you, sleeping in a park may indicate different issues than someone who is unhoused. So there are separate individuated tracks of the adult misdemeanor diversion program that our Buncombe County Justice Resource Center have put together. Then we have the felony drug diversion program as well. One of the critical things that I wanted to address in creating these programs, especially the adult misdemeanor diversion program, is because, like I said, police charge and then they come into the court system. We have a pre-screened set of charges that everyone who is charged is invited and notified of the program. In Buncombe County, folks in the Justice Resource Center are very kind to do this work. They analyze the dockets. They look at which charges are eligible, which offenders are first offenders. And then as they come into the system, they're all given kind of a greeting and advised of the program, and they can either voluntarily accept it or not. Perhaps it's time to go to the next slide. Yes. So I guess I would say, what we're trying to do is to be smart on crime. My office, our chief, I think all of my colleagues around the country, we're always going to be focused on addressing violent crime and maintaining, community safety by addressing violent crime chiefly. The programs that I'm describing emanate from the use of prosecutorial discretion, which is to create strategies to ensure accountability while addressing issues that lead to criminal behavior outside of the court system. And the reason for doing that is there are the collateral consequences that sometimes stem from not only a conviction, but a potential, arrest and then a dismissal, any kind of criminal record. So we created the Buncombe County Justice Resource Center to create that seamless linkage within the court system. I've always said that I wanted to create a program that would begin to transform our court system here from a place of punishment that's recognized as a place of punishment and accountability via punishment to increase access to healthcare, housing, referrals to education, vocational rehab, and those sorts of holistic services. Next slide, please. Felony drug diversion does reach out to our community and uses a peer support model. So we lean heavily on folks who have lived experience and can share that experience with folks who have been in the position that the participants are currently trying to heal from. The drug diversion, not only does it require meetings with a peer support specialist, there is accountability through I guess you'd say restitution via community service back to the community. As a point, upon entry, all folks that are going in to either the adult misdemeanor diversion program or the felony drug diversion program do I think it's about a 15 to 30 minute class, if you will, or PowerPoint, and then take a quick little true or false test about collateral consequences. I want folks to understand, the benefit of the program in terms of we're utilizing our discretion to take them out of the court system, and that there's a benefit to that. As opposed to, you're asking me to do all this extra stuff. Well, can't I just pay my court costs and the fine and go home and get out of here and have that guilty next to my name for the rest of my life potentially? So there's a little bit of education about the benefit of the program. And then there's peer support and community accountability. And of course, implicit in all diversion programs, is pick up no new charges. Next slide, please. Again, adult misdemeanor diversion tracks the similarly described protocols that I just mentioned. 3 to 9 months. Education, volunteer, and restitution as required. And we also have in the unhoused track created a kiosk and some other resources for unhoused folks so that they can come to the Justice Resource Center and work on their resume, log into their email, and do those sorts of things. Next slide. Is this back to Shauna?
Yes, unless you had anything else that you wanted to add, Todd.
Just that I think I made it somewhat clear that the jail diversion program that Shauna is involved with is separate and apart from the program that I just described. This is one of the things that I'm most proud of in terms of an infrastructure change here within the Buncombe County court community. The Justice Resource Center is actually housed at the Buncombe County, where the Buncombe County Jail was prior to 1996. So I think it's a good metaphor for change in our court system. And I'll end on that note. And I appreciate the ability to share.
Thank you, Todd, and congratulations. Just real briefly before we pass it back to Demetrius, want to talk about the one other service that we offer, the Buncombe County Reentry Council. This is a program specifically for individuals that are being released from incarceration in prison. And the pillars that they focus on are linking individuals with employment, education, transportation, and housing. This was a pilot program at one time because they noticed that individuals, especially individuals coming out of lengthy periods of incarceration, were really not given the skills, the tools, and the social support that was absolutely critical to them being able to get their basic needs met when they were released from custody. Next slide, please. And again, basically what the Buncombe County Reentry Council is meant to do is help individuals, especially after lengthy periods of incarceration, come back to the community with some semblance of supports to ensure that the community is able to employ these individuals and work with these individuals to ensure that they get their basic needs met, including their physical health, mental health needs. Getting people back to full-time employment is critical, especially when people are working to regain custody of kids, pay post-release fines, and and increase community safety. We want to engage individuals. We want to give them a safe place to be so that they are not left with a difficult decision to resort back to any illegal activity that could then put them at risk for further incarceration. And that concludes our portion. Thank you, Demetrius.
Thank you, Shauna. Thank you, Todd. I do want to acknowledge that I see hands being raised. After Evan goes through his presentation, we're going to circle back and acknowledge those who had hands raised and or questions dropped into the chat. With that being said, I want to kick it over to Evan Nepcong, who is the Intensive Forensic Services Supervisor at Deschutes County, to talk a bit about their program. Evan?
Yeah, thanks, Demetrius. Hi, everybody. Thanks so much for having me. As Demetrius mentioned, I'm a supervisor of a team here within County Behavioral Health that works with several different groups of clients that are all forensically or criminally justice involved and have severe and persistent mental illnesses. In the presentation today, I'm going to focus and kind of highlight on one specific group of clients that has grown dramatically over the past several years, and just kind of give an overview of how we've been working with those folks. But just for a little bit of context for those of you who don't know, Deschutes County, if you stuck a pin like right in the center of Oregon, that's where you would find Deschutes County. It's a county of about 100,000 people. Our biggest city is Bend. And so just to kind of give you a little bit of context of, sort of the size of the county and how some of the programs that I'm talking about might compare to, some of the places that you all are coming from. Next slide. So the purpose of my team, and my team was formed within the last couple of years to address a growing population of forensically involved mentally ill clients. But really the purpose of our team is to provide high quality mental health care for people with severe and persistent mental illness who are somehow involved in the criminal justice system, and there's a nexus between the commission of their crime and their charges with their mental health. Our team's goal is really to try to stabilize and provide treatment to all of our clients. But today I'm specifically going to be talking about individuals who are found unable to aid and assist. In other states, this is known as incompetent to stand trial, sort of synonymous with that idea. But folks who because of their mental health issues are unable to understand what's going on with the legal process, and therefore are unable to assist in their own defense. All of this while protecting public safety and reducing recidivism. Just one note about this population. I'd say in the past 2 to 3 years here in Oregon, at least what we've seen, and I think it's pretty much throughout the state, is that this group of clients has grown by anywhere from 300 to 400%, to the point where it has completely overwhelmed the state hospital. At this point, our state hospitals are no longer able to accept folks under civil commitment because they're dedicating so many of their beds to aid and assist individuals. And so we've seen this real increase. I don't know whether that's happening elsewhere in the country in the same way, but it really has become sort of the funnel for individuals who need some type of mandated or involuntary treatment, and are otherwise not willing to participate in the behavioral health treatment process. So we've seen this ton of growth. There's a lot of attention and fortunately money being directed towards it by the state legislature because of that. But it has kind of reached this point where it's almost a crisis because it's bogging down the whole system. So next slide. So, in thinking about not only, sort of what we currently do right now, my longer term goal, and I think it's very much the same as what I'm hearing, from the other presenters here and probably all of you as well, is just trying to find ways of catching this further upstream and really diverting these folks before they even enter the criminal justice system, certainly before they've got charges against them, and we're headed down that road. So, I think that's likely all of our shared goal. Probably, for years and years now, we've been trying to figure out this puzzle. But I do think when I think about our process here and kind of the trend that we're seeing in the state of Oregon, I think that so often what we're bogged down by are like these bigger systemic challenges. And I think from my perspective, waiting for these systems to change is a very slow process. And so I'm really focused on trying to find like local grassroots processes that we can come up with that involve collaboration with other partners here on a local basis that maybe we can use as a model. And so my goal eventually is to sort of intercept this process earlier on and come up with some type of diversion model that will hopefully reduce the number of people that are even found unable to aid and assist. Next slide. So in terms of eligibility, all of these individuals are ordered by the court. I'll get into the process of how that works here in Oregon in just a moment. This applies to both felony and misdemeanor crimes. There are no limitations on the charges that are involved here. The way that it works technically is essentially that the legal process is paused while the individual's competency is addressed. And once found competent, that these folks then would move forward with entering a plea, and sort of the justice system moves on as it normally would otherwise. I'll get into kind of how that actually happens in reality a little bit later on, but that's essentially the idea here. About 95% plus, probably even a little bit higher, of our folks are on Medicaid. Many of them are initially houseless when they come to us. We definitely see a pretty high co-occurrence of substance use. So all of those things are factors as well. Next slide. So just kind of a little bit about the process here. Basically, when a defense attorney identifies that their client is having mental health issues that impact their ability to understand what's going on in court, the attorney will raise these issues to court. The court will order a forensic evaluation, and that evaluation, if it finds that that person is indeed unable to aid and assist because of a qualifying mental illness, the court essentially then turns things over to my team to determine whether that individual is appropriate for placement in the community or whether they require a state hospital level of care, usually because either their symptoms are so acute that they're not even really able to or willing to participate in treatment on a community basis, or because of some level of dangerousness. Our team, for the folks who remain in the community or come back to us from the state hospital, we work with these clients in the community to try to restore them to the point of competency so that they can move forward in their legal process. Obviously, that not only involves sort of skills around the legal system and what's going on in their case and understanding of all of that, but also just stabilizing them or restabilizing them from a mental health basis, so that they've got a shot to really learn some of the things that they need to know to move forward. Next slide. So just in terms of sort of care coordination and referral sources that we utilize quite a bit, our behavioral health clinic here is a clinic that has an embedded primary care clinic run through a local medical organization. It has an in-house pharmacy. So there's a lot that we can do for our folks from healthcare needs, just basically in-house, which is really nice. The resources that we use most often are residential treatment, shelters, food stamps and food banks, Social Security, Medicaid, all of the things that you would expect for folks who are houseless, and maybe significantly, lacking in resources. Next slide. Just I guess a couple of our success points in terms of the coordination piece. I think most significantly that our team has put a lot of investment in developing relationships on a local level with all of these different resources. And we have, people that we can just call directly when we need something, for a client. And that's, I realize that that's not possible everywhere. If you live in a bigger urban area, this might not be quite as easy. We happen to be sort of in a sweet spot with the size of our county where we can actually know and build a relationship with individual people in each area of the system. So that's helped out quite a bit. And then just, frankly, the involuntary nature of this process makes a lot of things easier. And in Oregon, the court automatically orders for each of our cases that the information be allowed to be shared for the purposes of coordination. And so, we don't have to run around getting a bunch of releases of information and sort of wrangling with clients over whether or not they're okay with that. So the coordination for this particular population is actually much smoother than a lot of the other clients that we work with. Next slide. So the strategies that we're using are really just to provide wraparound mental health treatment, case management, resource coordination, peer support. On our team, we have 3 clinicians who are either licensed professional counselors or social workers. We have 2 case managers. We have 2 peer support specialists, and all of them are involved in some way of wrapping around care of these folks. Again, we're looking at what is the most appropriate and safe level of care for them to be in, whether that is living independently in the community, being placed in some type of treatment facility, or going to the state hospital. I'd say our biggest barrier here is that we have a huge shortage of treatment facility beds. And so getting somebody into one of those is pretty difficult. One of the things that we've piloted over the last couple of years is actually paying to reserve beds in a high barrier shelter, and that we can place people in who are appropriate and can be managed at that level. And that's actually worked quite well for people who are coming back out of the state hospital and have stabilized, but without that support or without a roof over their head, we could quickly expect them to decompensate in the community again. Next slide. So we also coordinate closely with the court, the DA's office, defense attorneys, and the state hospital to coordinate care and facilitate the most appropriate treatment setting. And attempting to reduce the state hospital backlog by coming up with alternative options. Like I mentioned, contracting with a high barrier shelter, working closely with our residential treatment programs. I would say that for those of you who are wondering sort of what the magic answer is for working with this population, I wish I had something that was a little bit easier, but to me, it's really just it's collaboration and the relationships that you build, and those are priceless. And here in Deschutes County, we've gotten to the point where every single week, every Monday morning, first thing, we have a meeting that involves our behavioral health team, the DA's office, pretty much all of the defense attorneys of all of the clients who are involved here. And we all get together on Zoom, and we talk through the cases that are on the docket for that day, and sort of what the plan is, what their current status is, giving the defense attorney and the deputy district attorney a chance to sort of sort through some of the issues that they're going to be addressing in court. Giving behavioral health a clinical voice in the room to kind of talk about what we think might be most appropriate or most helpful for the person. And I will say that that has been probably the biggest game changer of all of this, because we all then go into court with a plan for each one of these cases, and kind of knowing like where it's going to go. And I think that has really helped not only to streamline things, but just get everybody on the same page at approaching this from the perspective of both the individual and what's best for their mental health, and how we can hopefully achieve that. But also, setting up just this really collaborative nature of the relationship, and that it's certainly less contentious than what I've seen elsewhere in the state. Next slide. Other strategies are obviously like creating linkages with important resources like family, payees, guardianships. These are all things that we're using to try to help stabilize these folks in different ways. And then really working towards, and this is sort of our team's ultimate goal, is working towards ongoing engagement with longer term treatment. And I'll talk about this a little bit more later, but we've had some data that has significantly correlated this with reduced recidivism in this group. Next slide. Because the competency restoration process only pauses the normal sort of flow of the legal system, folks who regain the ability to aid and assist, they wind up still moving forward with entering a plea to their charges. However, we've had some interesting data come out recently that statewide here, once somebody is found able to aid and assist and moves forward with their case, only about 33% of these cases are reaching a disposition. The other 2/3 are dismissed. Charges are dropped, often because of this whole process has taken a year to a couple years, and they've already sort of gone past the amount of time that they would have served otherwise. At other times, it's sort of clear that that is the best thing for the individual. So there's a number of reasons that sort of factor into this, but I think it's just a key point that I want to highlight is that we're sort of doing all of this work in the interests of reaching eventual justice, and yet only about a third of these cases are actually reaching a disposition. And that's not to say that it's not a success, but I think again it sort of highlights the need to try to intercept this process earlier upstream, and kind of get all of these cases out of the courts and find some other way of managing them, and that being sort of a bigger, longer term goal. Next slide. So in terms of how we think about success, we think about success by how many of these individuals continue to engage with behavioral health beyond the resolution of their case. That is how our team defines it. I'm sure that our DA or the defense attorneys or the state hospital would define it differently, but that's how I look at it. The data that I track shows that for folks who have continued to engage with behavioral health, not even just my team, but somewhere in county behavioral health for 45 days or more following the resolution of their case, they were about half as likely to recidivate or re-enter this competency process as compared to people who just kind of dropped off the map as soon as they were done. So I think that, that it just really shows that even, a relatively short term of ongoing engagement can have some significant benefits. And we just sort of see clients who restabilize and then maintain that and are able to continue to work with the behavioral health team and for long periods of time without any recidivism. I think okay, one more slide. Next. So I think ultimately, like our sort of stated goal is to restore these folks to competency, but as I mentioned, I think an equal amount or more of our efforts are really placed on trying to develop a positive relationship between the individual and our behavioral health system, so that the hope being that they'll continue to work with us even beyond this process. And I just think that we've seen it work again and again, where we get somebody who is extremely psychotic, extremely unwilling to engage at the beginning of this process, and by the end of it, we're actually able to maintain ongoing services for them. So those are really our real successes. I think that's the last slide. Thanks.
Thanks, Evan. Before we go into the facilitated questions piece, just wanted to hold some space to see if you all had any questions directly asking Shauna, Todd, or Evan about their program. I see Miriam has dropped a question into the chat. And I believe this question is for Shauna and Todd. Miriam, and if I'm wrong, just let me know. And the question is, are these services available to people who are both in prison and in the county jail?
In terms of the Justice Resource Center, and the peer support components and various other resources that they offer are actually open to the public. You don't need to be charged with a crime to access it. Now, in regard to Shauna's program, I'll turn it over to you.
So we have two separate tracks to support individuals with reentry. We have the Buncombe County Reentry Council that has funding specifically to help folks that are getting released from prison. And then we work with a case manager and two peer supports in the community that are specifically meant to help individuals as they leave the jail. We have our presence, our offices are in the Buncombe County Detention Facility, the jail. We unfortunately don't have that same presence in the prison, but we do have those supports available to folks when they get out of prison. And what we try to do when folks are in the jail, typically they're incarcerated until they're shipped to DOC. We try to get them a meeting with someone from the Reentry Council before they go to DOC so that they can meet with, talk with, and share some of what they're going to need when they get out with the individual so that they feel more comfortable to reaching out when they're released from prison.
Thank you. Oh, perfect. Thank you. Miriam says thank you too. So I see a hand raised. If I pronounce your name wrong, when I take you off the mute to speak, just say your name for us. The next hand I see is Adeline Cruz. Adeline, do you want to ask your question?
Yes, thank you. You did very well, by the way, in the pronunciation. I have a question for Evan. I'm sorry. Talking about butchering names. For the people that are incompetent to proceed, or what we call ITP for short, when you offered first, I'm impressed that the court system will reach out to you before adjudication or competency or anything like that. Congratulations. That's something that we're trying to do here in our circuit for a long time. And we usually get pulled in a little way later than that. But you've mentioned that the people you're able to put in the community. I'm not sure where you're from. I think I missed like the very beginning of the introduction. And how do you deal with informed consent, like the ability to provide consent for those people that are at ITP and that are coming into community treatment for outpatient services? I mentioned where you're from because there are statutes like require you to express informed consent and the whole signature of signing it. And our people that do go to the community that are ITP are on conditional release, very strict conditions of release. And oftentimes they don't engage. So I want to know how, is everybody saying, yes, I want to participate, or how do you deal with that?
Yeah, all good questions. I'm from Central Oregon, Deschutes County, which our biggest city here is Bend. So here, yeah, I think that it's basically addressed through the court order and through the court order to participate in services with us. So a lot of these folks are certainly not voluntary, far from it, and certainly do not either want or also more often understand why they're suddenly involved with my treatment team. And so that's certainly, you know, I think that the piece of like the informed consent is addressed by them being under this court order, but the piece of how we actually engage and work with somebody like that is definitely the more complicated one. You know, I guess I would just say that our team was developed to approach things from kind of like an assertive community treatment type of approach, meaning that we are not waiting for people to come to us. We are going out, we're in the homeless camps, we are knocking on motel room doors, you know, we are very assertively working to engage these folks. And quite honestly, like a lot of times we have to offer them some incentive initially to start working with us. And there's a real balance of trying to get somebody in the door, show that that you can offer something of value to them, and then gradually work on the relationship from there. And it's certainly not successful, you know, all the time, but I would say that you know, our team has just gotten really good at kind of finding that balance and finding a way to engage with somebody that doesn't come across as like we are representing the court or we are some type of like, you know, monitoring arm of the court, that we're really here primarily with the goal of helping you and helping you with whatever your goals and needs are, and that we're going to prioritize that first, and then we're going to work on, you know, this restoration to competency process. And so, yeah, I mean, I think that's sort of how we've approached it, and we just kind of take a like by any means necessary approach to it all, whether it's from a incentive basis or just, you know, just going out and tracking people down.
Thank you for your answer. I mean, the competency portion is mandatory for our circuit. The treatment portion, well, community-placed individual, that's what becomes much more a gray area, right? And I see you shaking your head.
Yeah,
agreeing that that's
definitely.
kind of what happens everywhere, I guess.
Yeah, I mean, I think, you know, for these folks that we're working with, they are ordered to participate in treatment, of course, whether that, you know, that happens and they follow through or not, is the question. Yeah.
Thank you so much for
Oh, all right, thank you. Any other questions, feel free to raise your hand or drop them into the chat. I had a question, and David, feel free to jump in anytime. I had a question, and this question is for Todd. Todd, you discussed doing a systems analysis when you got into office to look at some potential diversion programs. Could you talk a bit about that process and who was at the table as you thought through that process? And any tips that you can give anyone on the team in terms of how, if they don't have DAs as industrious and progressive as you, the idea of how to approach a DA to do a type of systems or mapping analysis for folks who want to start working with prosecutors in developing a potential diversion program?
Well, a lot of that systems analysis and it was initiated just by looking at the lay of the land. I defeated my predecessor with about 70% of the vote in 2014. And Buncombe County, as a Shauna's predecessor was in her role prior to that, and Buncombe County had made jail population management, you know, a real critical focus long prior to me being DA. So there were municipal decisions made. You know, the North Carolina legislature in Raleigh gave us They give us our statutes, they give us our penal code. And, you know, there's so much talk about bond reform. Bond reform has kind of been in slow motion development here in Buncombe County for 2 decades. We had a risk assessment, the Virginia VPRA, I forget what the initials stand for, and now it's the Arnold Foundation algorithm that perhaps many of you are familiar with. But a lot of low-level offenses were referred out of they were not housed, like maybe 20, 30, 40 years ago in Buncombe County, folks that were charged with public urination would be locked up or have to do a night or 2 in jail until they had their first appearance in court. And that was the hammer, right? And potentially you're going to do longer. You're going to do another week. You're going to do 2 weeks. But in North Carolina, those kinds of offenses generally only carry about 20 days maximum punishment. So what are we doing with these tickets? Basically, they might be arrested, they might be taken to Buncombe County Jail, but generally, long prior to me being here, these had been deprioritized for carceral solutions, if you will, right? But the DA's office hadn't really responded. And so the DA's office was still using workarounds in terms of formal court processing and an analysis of statistical, like conviction rates and those kinds of old school, if you will, approaches to criminal prosecution. We're not going to dismiss it. You got to plead guilty. You can plead guilty because you're a first offender, and then we'll do this hoodoo on the back end. We'll dismiss the charge, and then you can maybe get it expunged if you've not picked up any new. And there are questions about, was it really a conviction? Like I said, we were always taking these calls from armed forces recruiters. Like somebody had pled guilty to misdemeanor marijuana possession. I understand the armed forces has changed their approach to marijuana possession in the last few years, but in 2015, we were getting these questions all the time. Did they go to court? Did they plead guilty? Were they sentenced? So while our prosecution-led diversion program has, I think, knock-on effects to hopefully reduce jail population, its main priority is to achieve justice by basically, the hammer here is the inducement to change behavior is the potential criminal conviction and the collateral consequences of that criminal conviction. And that's why when they're coming into the program, they're educated about collateral consequences of that conviction, the value of a dismissal that comes not through a formal guilty plea, or I referenced very much in passing as I was gliding through North Carolina law, a formal deferred prosecution, which again is an admission of guilt. It's not a guilty plea, but then it's a form that's signed by a judge and there are probation officers on the case. All these things were criminal processes that we had in Buncombe County that were utilized, but they were formal and they had collateral consequences. We wanted to transform that so that it was just a dismissal in the interests of justice. And that's all anybody could ask about it. We wanted the in the formal court file, dismissal, check the box, in the interest of justice, prosecutor signs it, it's gone, it's out of the system. Then the next stage could be potentially an expunction, petition for an expunction, and wipe the charge from the record, wipe the arrest from the record, wipe all other records from the public record. We wanted to put people in that position. And so I lost my train of thought, just felt like I was going someplace next. I forgot where, but that was critical. I felt like there were too many ethical issues. People weren't understanding the process of like, hey, the way you get relief as a first offender is to plead guilty. I just felt like that was kind of toxic to our integrity as judicial officials here in Buncombe County. Is that responsive to the question?
Yes, thank you, Todd. And as you talk about looking up the laws and things, Evan, I'm going to come to you. We have a question about the structure of your team, but before I kick it to you, Todd, you were talking about looking up the laws. Someone, I think it's Miriam, just asked the question: does North Carolina still have the 9096 for the first felony offense? I guess that's the penal code there.
9096 is something that, as a public defender, I used all the time. Yes, I believe that's still on the books. However, North Carolina, again, this is Raleigh when I say North Carolina, has added some new provisions post-charge that allow for additional opportunities for diversion, and it's called conditional discharge. Again, usually that requires it's like treatment court for everybody and every kind of charge up to a Class H felony, which is generally a nonviolent, property type crime or drug possession. You plead guilty, you go on probation, and after a year, you get a review date, you come back to court, and your charge can be dismissed. So that's something that North Carolina has added to justice reform. And again, I think Demetrius used the word progressive. A lot of justice reform, I think, is conservative. It goes beyond political labels, because our legislature here in North Carolina has been Republican supermajority, veto proof for a good while since I've been DA. And a number of justice reform initiatives have come from the North Carolina legislature, conditional discharge being one of them.
Good to know. Definitely good to know. Evan, this question is for you. How does your, coming back to you, thanks, Todd. How does your behavioral health team operate? I guess the question is staffing, hours, and that type of thing.
Yeah, Eric, I want to just make sure I really address your question. So I'm wondering if you're on and you're unmuting kind of specifically, if there's areas that you're wondering about. I can tell you kind of generally like the makeup of our team and how we operate, but I want to make sure that I'm answering your question.
Eric, you should be allowed to speak, no pressure if you want to, or feel free to drop it in the chat. I think I've taken you off of mute. Or feel free to drop your question in the chat.
I guess just generally that I would say that
Can you hear me?
yeah, oh yeah, I can hear you.
I was just, I guess in general, I'm wondering, we're starting a behavioral health team here, and we have two doctors on board, and I'm the jail diversion coordinator here in Guilford County. So I'm just trying to get the infrastructure of that. So I was just, when you mentioned behavioral health team, I was just curious to see how you guys operated and what was the infrastructure of that.
Yeah, definitely. Okay, thanks. Well, so our team is a part of county behavioral health, and so we are sort of like the largest provider of community mental health services in the area that we're in. The county as a whole has a number of different teams that make up the behavioral health system here. So my team specifically was created a couple of years ago specifically to work with any forensically involved individuals who had severe mental illnesses. And I think that sort of from like a funding perspective, initially when we first started up, some of this was grant funded, a combination of grant funded, public funding. Just sort of cobbling together enough funding to be able to form a team and hire the number of positions that we needed. We have a total of 7 staff on the team, plus like a part-time psychiatrist and a part-time nurse. But I think that to me, in working with these populations, almost more just as important as the sort of clinical staff, like a qualified mental health provider, a therapist, a social worker. To me, just as important are the case managers, And on our team, we utilize peer support quite a bit as well. And so, oftentimes like those are the staff that are actually able to connect with our clients, in a different way than maybe a clinician would, connect them to different resources and that kind of thing. So if I were forming this team again, I would really like put a heavy emphasis on the case management elements of it, on the staff who are going to be able to form connections based on lived experience with some of our clientele. And fortunately, like we've been able to come up with some really excellent people for our team, who provide that piece, and it makes a huge difference.
Thank you, Evan. I appreciate that.
Yeah.
So we are exactly at 3:30. I want to be respectful of folks' times. I'm going to do the wrap up really quickly, but in the meantime of doing the wrap up, please feel free to drop any remaining questions into the chat. So these next two slides just address some resources that we all have available for you that have been developed by CSG and by some of the presenters. I really want to, and I'll drop those into the chat just so that you'll have the links immediately. I really want to focus some emphasis on the financing the future local initiatives. That is a suite of information, a suite of materials that includes a handbook, a worksheet, as well as local initiatives that you can potentially work with and to think through how to develop sustainability measures for your program, as I know that's huge for a lot of you. And I'll drop these links into the chat. The next slide is the contact information. The next two slides, is the contact information for all of the presenters. Our presenters graciously provided their direct contact information. I think you should feel free to reach out to them if you have any further questions, but please do that sparingly and don't just bombard them with a rack of questions. Let's be respectful of their time and appreciative that they were able to drop their contact information in. And the next slide is to thank you all, and just a reminder that if you haven't done so already, so please sign up for the Council of State Government Justice Center this newsletter. That's an opportunity to receive updates and announcements on our webinars, other resources, and other tools that we have for the population that you all are working to serve. And it also includes opportunities for you to hear about other funding opportunities. So with that being said, it doesn't look like any other, I'm trying to copy this for you all. It doesn't look like, I don't think I'm going to be able to, but I'll definitely share this later. We'll share the PowerPoint later that will have all the resources linked. All right, if there are no other questions, I want to thank you all for joining us. I want to thank all of the presenters for participating. Thank you so much. I really appreciate all the efforts and work that it took into putting these slides together and your participation in the overall webinar. So thanks everyone. Have a great day and take care.